So where are we? There is a debate as to whether the use of online platforms and search engines can lead to serious harm to its users. Now, part of the content that is created and disseminated in these platforms is already considered to be illegal, it's criminalized, and it's prohibited. Yet there seems to be a serious concern that some of the content that is still legally permitted online can still pose serious risks of harm to children and adults. The UK is creating a new bill that is currently debated in Parliament that seeks to make the UK the safest place in the world to go online. That's an ambitious strategy or an ambitious goal, considering that the UK aims to depart, as other speakers explained, from important data protection standards. The focus, however, now is not as much on data protection, although we'll see that data protection remains relevant, but it is on harmful content. And my understanding is that this legal reform tries to fill in a threefold gap. First, there's a normative gap. We don't know what content causes harm, and we don't know who should be empowered to determine what is harmful content and who should be empowered to do something about it. There is also an enforcement gap and an accountability gap. We were not sure until now who should be, what happens to harmful content and what happens when online platforms and search engines fail to take measures to address harmful content. And finally, there seems to be a transparency gap. Users are simply unable to determine how exactly platforms will assess their content. What is the decision making that may lead to the moderation of their content online? The relevance of these reforms to data protection was nicely explained by Dina yesterday, and it is twofold. Well, the first one is that data protection breaches is one of the most frequent violations in the online platforms. And secondly, data protection is one of the values, one of the legal rights that is balanced when a platform is assessing how to moderate harmful content. And I want to make clear that the scope of my presentation will not focus on children, but will just focus on adults. And I need to make an important distinction between two categories of content that is regulated by this reform. One that is called illegal content and one that is called legal but harmful content. I will not engage with illegal content, and I'll simply focus on what is called legal but harmful content. If I can say a word about illegal content, it is worth noting that the UK is introducing new criminalized communications. So it would be a criminal offense if someone shares distressing content or disseminates false information, acts that can be described as cyber flashing and threats would now be criminal offenses. But let us now focus more on what I understand as legal but harmful content. The bill gives a definition of harm, and that definition is that harm concerns inflicting or increasing the likelihood of physical or psychological harm from A to themselves or from A to B to another person. And it makes a broad distinction between two categories of legal but harmful content. The first category concerns kinds of content that are explicitly designated as harmful in subsequent delegated legislation. Essentially, the minister will issue a regulation that will list categories of harmful content that would be non-debated as to whether they can cause harm and whether they should be moderated. This is what is called priority content. The second category concerns the type of content that the legislator acknowledged that is currently unknown. and it gives the discretion to the online platforms to make a decision based on their own assessment as to whether they present, and here is the test, whether they present a material risk of significant harm to an appreciable number of adults in the UK. This is the non-priority content. Now, an interesting question that immediately arises, how can we determine what is non-priority content? How would online platforms do that? And it essentially is going to take place on a case-by-case basis, but platforms are permitted to recognize new categories of harmful content in addition to the ones that would be mentioned in secondary legislation. What is perhaps exceptional and remarkable, and it is linked to the theme of this panel, is that the bill expressly authorizes the use of artificial intelligence and machine learning tools to assess whether some content is harmful or how to treat it. Particularly, the legislation authorized the use of content moderation tools, user profiling tools, and behavior identification tools. But even more, the bill empowers executive agencies within the UK to require online platforms to use artificial intelligence towards complying with their legal duties. But what are the new legal duties that are imposed on online platforms? To put it briefly, the bill creates a new duty of care of online platforms to its users. And this is translated to a set of concrete legal obligations. There are obligations to conduct risk assessments, to take steps to mitigate or manage risks of harm to individuals, and there are specific provisions that require these measures to adhere to the principle of proportionality and conduct a balancing exercise between risks of harm and other fundamental rights and public values such as freedom of expression, privacy, journalistic content, or content of democratic importance. I think another novelty is that there is a duty to explain in the terms of service how precisely each kind of harmful content will be treated. The user needs to know in advance whether certain types of content would be taken down, would be restricted, or the promotion of that content would be limited, or there would simply be a recommendation to the user. There are new obligations to create processes that would enable users, and in fact, any person that is affected of any content online, to report and complain about that content to the online platform, and there are notification duties to the executive agencies in the UK. There is also a user empowerment duties where users are now having more discretion on more control over what legal but harmful content they can see and with whom they can interact. And there should be mechanism in place that would alert users on potentially harmful content before they open that material. I think we increasingly see these tools already applied. But I think one of the most interesting parts of this suggested reform pertains to its proposed mixed and multi-layered enforcement structure. Now, the responsibility to manage and moderate harmful content and users rests exclusively with the online platforms. In this sense, public law will not directly impose any obligations or sanctions on individual users for legal but harmful content. The immediate source of any duties on users would be private law, essentially the terms of service of each platform. Now, while the state will not directly interact with the harmful users or the harmful content, the bill sets up a robust and comprehensive public enforcement mechanism where Ofcom is at the center of it and seeks to ensure that platforms will adhere to the new duties. And Ofcom really enjoys a remarkable range of powers. It has the power to compel a platform to provide information, has the power to conduct on-site inspections, and it has huge powers to impose high financial penalties, up to 10% of the worldwide revenue of that platform. That's, if you think about that, that's extremely high. And there is also a judicial enforcement mechanism where if platforms fail to comply with the requests of the Ofcom, then the Ofcom can go to court and ask the court to impose business disruption measures on that platform provider. Focusing now on regulatory powers, my understanding is that the bill provides for a hybrid regulatory blueprint. It includes public and private rules, as well as hard law and soft law measures. Primary legislation offers the broad normative framework, which includes a catalog of new obligations for the online platforms, but then secondary legislation will identify specific types of content that is considered to be harmful, but how its kind of harmful content will be treated and determined would be governed under the terms of service for its platform. And finally, executive bodies will be able to issue soft law measures to further guide online platforms on how to comply with the legal requirements. It goes without saying that the law covers platforms that are based outside the UK, but has some links with the UK. So we're talking about an extraterritorial effect of that bill, to the extent that the platform has significant numbers of users in the UK, or the UK is the target market of that platform, then it is subject to this reform. And perhaps a few reflections. My understanding is that the bill attempts to introduce a regulatory framework to control the online darkness, one could say, that currently escapes the scope of hard law. Now, from one point of view, the proposal is not an extraordinary invention. I mean, services provided by private parties which are in the public interest, or somehow blur the boundaries between public and private domain, are typically subject to public regulation. States do have a moral duty to protect their citizens and their well-being, after all. They also enjoy the democratic legitimacy to set boundaries to human behavior. And perhaps the democratic process, at least theoretically, leads to more equitable policies and rules, and is able to offer a level of protection to the more vulnerable parts of the societies. If that is not enough, well, online platforms have been permitted to act for a long period of time unregulated, at least not under public regulations, and some of the attempts that were made to regulate through self-regulation or through soft law, multilateral arrangements, were not necessarily as satisfactory as they could have been. But I think it is important to take on board that we see a high distribution of regulatory and enforcement powers. There is a decentralization of regulation between the public and the private sector. In a way, in my mind, online platforms will become enforcement agents of the state. And that is because the state practically depends on the platform's cooperation to identify and deal with harmful content. At the same time, there's distribution of power within the states. We have allocation of powers between different constitutional actors, the parliament, the core government, executive agencies, and the courts. In terms of the approach that the bill takes, it's preventative, in my view, rather than reactive or reparatory. It does not require proof that the content has caused harm to an individual, and endorses a risk-based approach, which means merely establishing that certain type of content poses material risk of serious harm would suffice. The bill does not explicitly recognize different levels of risks, and this leads us to make a few points here. The first is that defining risk of physical and psychological harm would not be an easy task, and grants, in my view, a considerable margin of discretion in the hands of the online platforms. Second, by designating categories of harmful content, the legislator tries to reduce the subjectivity that inherently governs any assessment on what is harmful, and it tries to influence the decision-making of the platforms. The third point is that the actual degree of discretion that is left to the platforms would depend on the level of detailed guidance that would be provided by secondary legislation and soft law. So the government has the capacity to increase or decrease that margin of discretion. And finally, there will always be borderline cases where that would always challenge the conceptual limits of any classification. system. Moving on to some of the final points. I believe that the description of certain content as legal but harmful is misleading. It creates the perception that this type of content is not subject to legal consequences. And I think this is far from the truth, as the bill not only authorizes, but essentially creates new legally enforceable duties on platforms, even though the platforms have a margin of discretion in the choice of means to employ to moderate the content. The key difference is that the legislation does not directly criminalize the creation or dissemination of such content per se. Users who create or share harmful content will likely suffer other consequences that arise from private law, depending on the terms of service of its online platform. However, to the extent that the state encourages online platforms to punish users that create or share harmful content, the duty of care of online platforms to the users is, in my view, practically passed on to the users themselves, who will be incentivized to change their conduct to avoid facing adverse consequences. The legal reform, I believe, will likely have an impact on online platforms. Platforms would no longer be subject to moral and social pressure, merely to moral and social pressure when moderating online content. There are new legal risks that would shape part of the platform's business model. At the same time, the bill may also bring some relief, because independent regulation would lift some of the decision-making burden which currently rests largely with the service providers. And perhaps a concluding thought. And to do that, I would step back from that bill for a moment and try to think about what is the underlying moral question here. And the way I conceive it is that there appears to be a problem of competing individual and public interests. On the one hand, a person has an interest to be protected from online content that can cause harm. On the other hand, the same person has an interest not to suffer harm as a result of facing restrictions from accessing or sharing potentially harmful content. And if that is not enough, next to these individual interests, there may be an additional interest of public importance, journalism, the democratic process, and others that need to be safeguarded. What, in my view, is clear from the bill is that by requiring a balancing exercise between legally permissible but harmful acts and other legal rights, the bill essentially upgrades the normative value of safeguarding harmful content. Perhaps the key question is what price we're really willing to pay to enjoy a cleaner, safer, and healthier online environment. One may suggest that the safest online environment necessarily equals a sterilized and censored internet, which somewhat departs from the social paradigm we enjoy in physical space. Are we coming ourselves into a splitting, a paradox? Are we creating two parallel universes where the same behavior would trigger different legal consequences based on whether it was carried out in the physical world or the online world? Are we creating different standards of protection of certain fundamental rights? Perhaps the way forward, and that's the problem, is how to balance between advancing a sense of self-responsibility of users to think by themselves how to use online platforms, and on the other hand, protecting the most vulnerable groups of our societies when they access these online services. Thank you so much.